you everyone for braving the weather to come out tonight. Thanks to those who are warm and dry at home on Zoom. My name is Carolyn Murray. As a member who's present asked a few moments ago, my relationship to the town is my firm is KP Law, and we serve as town counsel to the town of Cohasset. And I am the town's, I've been honored to be the town's primary contact for, I guess, about the past 3 years or so. Tonight's training, as it indicates on the screen, is on the open meeting law. I understand that this whole presentation has been provided to Megan so that she could also post this on the town's website or share it for folks who might want to look at it later or need a resource or anything like that. I tend to prefer in trainings, if you've got questions, ask them. Because I could just send you the packets and say, read along, and you could all read along, because at least so far, it seems everybody here is a member of a board. Is that correct? We don't have any staff folks here, right? Okay. So there's a lot of this that you're going to be familiar with, but then there's also bound to be some little nugget in here that you want to ask a question about. So please feel free to do it as we go along. Oops.
If you are on Zoom and you have a question, just raise your hand via Zoom and I will allow you to ask your question. That's the way you would do it virtually.
So are you able to advance or do you want me to advance?
Do it, just give me a. Okay. Ready.
This first slide is really just as a reminder to everybody that this is really just about a training. We are not here tonight to talk about any specific situation or, gee, I think that this board violated the open meeting law last week when they did XYZ. We're not here to talk about any specific situations. If you've got a hypothetical question you want to ask, go for it. But this is not, if there's a specific situation that you want to discuss, we should do that privately offline. So can we go ahead just one? Sorry. So just to let folks know, obviously, we're going to cover the open meeting law, but we're going to talk about what's a meeting, what's a deliberation, emergencies, posting requirements, executive sessions, some of the pesky little things about hybrid meetings, preparation of minutes, the complaint process, and a little bit about the enforcement process. But again, I'll say you can save your questions to the end, but feel free to also just ask as we go.
What's the worst problem that's happened in Cohasset, a violation of the open meeting law?
Well, Cohasset, at least in my limited 3-year experience, has been blessed with very few. I can only think of one open meeting law complaint that I have actually responded to since.
Can you just describe it without details?
My recollection was that it had something to do with, I know it involved the Community Preservation Committee. I just can't quite recall off the top of my head what the specifics were. But that's the only one. Now, consider yourselves lucky. 2 other towns that I'm primary contact for, they get an open meeting law complaint at least once a week. And it is just a cottage industry. There are certain, there are certain folks in some communities that feel that it is their job to enforce the open meeting law, even when it might just be the most minuscule aspect of it. And you can spend a substantial amount of time and money responding to these things. And sometimes you want to say to folks, why don't you be part of the solution as opposed to just filing a complaint? But I haven't been able to convince them of that just yet. So why don't we begin? Thanks, Megan. So I think everybody here, as being a board member, you certainly know what the open meeting law is. Some states refer to it as the sunshine law, but it's all this concept of we are public officials and taxpayers and members of the public have a right to see government and action. And this permeates whether it's the meetings that you have, public records that you generate or that you might be custodians of, And you also see it with respect to the conflict of interest law. We're not going to talk about the conflict of interest law tonight. A little bit of the public records law overlaps with the open meeting law, so I will touch upon that just a little bit. But just so folks know, I think it was in 2010 that the legislature revised the open meeting law. It hadn't been tweaked in quite some time. And it used to be that the open meeting law complaints were enforced by the district attorney's office. And you can just imagine Superior Court district attorneys have got far better things to do than to come after, a board member for a violation of an open meeting law. So in 2010, the law was changed. The Attorney General's office, there was a new division that was created called the Division of Open Government. And it's now that division that receives all of the open meeting law complaints that we respond to, and then is involved with issuing any determinations. When the law changed in 2010, one of the things they also did was they gave the open meeting law a little bit more teeth. It used to just be, you sort of got a slap on the wrist, don't do that again. Now the Attorney General has power to nullify any actions you took if they were in violation of the open meeting law. They can also issue monetary fines if they find that you have intentionally violated the open meeting law. I've seen so far 2 intentional fines be meted out by the AG's office. They aren't terribly high, but they're enough to send a message to stop doing whatever it is that you happen to be doing. So can we go to the next slide, please? So a couple of things that we need to understand, obviously, when we're talking about the open meeting law, we need a meeting, but we need a meeting of a public body. And we need a quorum of that public body. So these are going to be a couple of aspects that we'll go into a little bit more detail here as to what it means. So first of all, the open meeting law only applies if you are a public body. So if you are the town manager, you're the school superintendent, you are an individual, you're a town officer, you are not a body. But if you're the select board, you are the school committee, you're the zoning board of appeals, you're the affordable housing committee, you are a public body subject to the open meeting law. What that then means is we cannot have a quorum of any body communicating. And we'll talk about what forms communication actually takes. But it's a pretty expansive definition. Bless you. That, quorum as a general rule is a majority of your board, depending upon how many members you happen to have. There's one exception for conservation commissions, that a quorum is a majority of the members then in office. Versus the zoning board of appeals, for example, is technically 3 permanent members, quorum is going to be 2. If they had a vacancy in one of those 3 positions, that doesn't make it a 2-member board, it's still a 3-member board. So any 2 members communicating with each other would constitute a quorum. We can go to the next one, please. So what is a meeting? And this is where I mentioned it's a very broad definition, but a meeting is basically anytime you have a quorum of the public body communicating, or the open meeting law likes to use the word deliberating on any matter or business that either is before it or may come before it. So really anything that's under the board's jurisdiction. We cannot have a quorum of any board discussing any matters that come under their jurisdiction outside of a publicly posted open meeting. So if you run into somebody at the grocery store or the soccer field or whatever it happens to be, and the 2 of you or 3 of you might constitute a quorum of whatever board it is you serve on, the best practice would be to make sure your conversation is really just about soccer or the weather or something that's just general, but don't suddenly find yourself saying, boy, we got quite the agenda coming up on Tuesday night, and I don't know how I'm going to vote on this particular matter. That now starts to get into a communication where you're expressing perhaps some opinion or discussing business that has to be within the context of an open meeting law. of a public posted meeting. What does a meeting not include? It does not include going out to an on-site inspection for any particular reason. Typically, that's a little more common, say with land use boards, but there might be other reasons like, you're applying to MSBA for some school funding. And maybe the school building committee wants to take an on-site walkthrough of the school building to assess the conditions. Or as I mentioned, maybe the land use boards get an application for a particular development and folks want to go and see the site and get the lay of the land. You can do all of those things without posting a public meeting. The only thing to bear in mind is you can't deliberate, which becomes really tricky because how do you, especially if you're, say, that member of that building committee, how do you walk through a school building and not talk about the roof that's leaking or the windows that are rattling or whatever else it happens to be? So if the chance is that you think that there will be some communication among the board members about the business before you, post the meeting. It's always a best practice to go ahead and post the meeting. But if you can limit yourself to just walking, getting the lay of the land, so to speak, and not communicating any further with your board members, you could get away with not having to post that particular meeting.
But if it's just comments, not deliberation, what's the problem with that?
Well, when we get to the definition of deliberation, you'll see the Attorney General really considers almost anything you say that is about a project or something before you is going to be considered a communication.
But, I mean, you're walking through the school building in your example, when you see that the roof's leaking. Would you point that out to your colleague to say, see that?
I think that's fine.
Yeah.
Same way that if the land use boards are walking a site and say, okay, so this is the boundary line, or this is where the wetlands begin, or so the building would be approximately here. So yeah, pointing, say, see the hole in the roof, or see the signs of water damage over there in the corner. I think things of that nature are fine.
Okay,
Anything beyond that, and it's hard to stop ourselves from going much beyond that, but beyond that could arguably be, crossing the line from the lay of the land to a deliberation.
Okay.
So a meeting also does not include, a quorum of a public at a gathering such as this. If we were all here for a training this evening, even if you had a quorum of the board, would not technically count as a meeting, provided you don't sit next to each other and talk about any business. And it does not include a chance social event. So, a retirement party perhaps for somebody, or, maybe there's a holiday party that is frequently attended. It's perfectly fine for a quorum of the board to go to those things. Just bear in mind, you probably don't want to be seen off in the corner with a quorum of your board members looking like you might be whispering about something that should only be discussed during a public meeting.
They lured us in with those delicious
Cookies
desserts
and things like that, right? I know.
Love it.
So talk about how delicious the cookies are.
Anybody that likes those cookies should vote no.
Well, there, now we've crossed the line, right?
I'm having a cookie, but I'm being rained on.
I'm being bribed. Oh, sorry, that's the conflict of interest law. We won't be covering that this evening. Meetings also apply to subcommittees or working groups. I get a lot of questions about this from time to time. A general rule, going back to my earlier comments where I said, the town manager and the school superintendent, they're not members of boards. So they can appoint a working group or subcommittee that reports back to them. And technically, their subcommittees are not subject to the open meeting law because they are not subject to the open meeting law. But if the school committee or the select board appoint a committee like, the town hall building committee or whatever we're calling it, that becomes a subcommittee that should be posting its meetings because it reports to a board that is subject to the open meeting law. Now, there has also been a couple of decisions that have come out of the Attorney General's office about subcommittees that kind of erodes away at what I just said, that if you're an individual appointing a subcommittee, then maybe your board is, that subcommittee does not have to comply with the open meeting law. The Attorney General has started to get a little bit more specific as to applying a test, what is this purpose of this subcommittee? Is it a committee that exists within government? Well, I think that goes without saying, every subcommittee appointed by a public official is going to be in government. We're not talking about like a neighborhood association, for example. But now the Attorney General's focus is actually looking at what is it that the committee has been charged to do? And what authority have they been given? Like what type of, decision-making, authority, if any, have they been given? So when you compare that, this kind of strain of decisions coming out of the Attorney General's office, it almost suggests if you're a subcommittee or a working group, post your meetings too, because there's a very good chance that the Attorney General might still say, yes, you might be appointed by the school superintendent or the town manager, but because of the work that you're doing, or because of the product you're actually going to deliver to the town manager or superintendent, the Attorney General is kind of looking a little bit more strictly that subcommittees still would fall under the open meeting law. So when in doubt, post.
But then the subcommittee is a subset of the total committee, so then the majority thing, how do we figure
It
that?
could be or it could not be, right? So your subcommittee could be, I want my DPW director, I want, my police chief and fire chief. They could be people who are not associated with the committee. If the subcommittee is a quorum of the committee, so if you say you had perhaps a 7-member board and you form a subcommittee that consists of 4 of them, you still have a quorum of that board, so you'd have to post those meetings anyway.
So we can deliberate, but we just have to post them and do
Yes.
the minutes and the whole works.
Yes,
Okay.
yes.
But back on the
Because I
forum
think-
issue, again, with your example of 7 people, what if it's 2 people that you put on a subcommittee?
Again, look back to, okay, is it a quorum of what I'll call the parent body?
Well, the quorum of the parent body is 7.
So 2 is not gonna be a quorum. So you're not going to have to post the subcommittee because you have a quorum of the parent committee. But you probably will have to post the subcommittee by virtue of the fact that it's a body created within government, serving a government purpose and designed and authorized to take some kind of action. So,
What if it's not designed to take action?
Right.
It's only gonna provide
Research.
advice.
well, even with that, and I'll give you a perfect example, screening committees. Those are often, if we're looking to hire a new school superintendent, for example, there's often a screening committee that will be formed. And quite often, there won't be a member of the school committee on that screening committee. We want these 5 or 7 other people in the community to vet and review, kind of winnow down the field of candidates for us. The open meeting law still says they are subject to having to post their meetings. Now, screening committees might not have been the best example that I gave you, just because they are allowed to meet in executive session up to a certain point. So they still have to post their meetings, but they can hold those meetings in executive session until they get to the point where, if they've now narrowed the field to say 3 candidates that they're going to hand over this slate to the school committee. Doesn't matter whether it took them 1 meeting prior to that or 15 meetings to winnow the field down to, here are our 3 recommended finalists. The moment we're down to those 3 finalists, we switch from executive session to open session. And that slate goes over to the school committee, but they still have to post their meetings. They still have to keep minutes of their meetings,
Of all those executive sessions.
of all those executive sessions, but none of that would be released until really the superintendent position is filled.
Yeah, I've got a question on quorum. My board, and I think some boards, but not all, have regular members who are voting and associate members who do not vote. If an associate member talks to a regular member, is that still, in our case, 3 people? Is it-
Well, I think we'll probably turn on whether or not is that associate member sitting on the panel for purposes of voting. And sometimes we don't always know that, right? You might have the zoning board might impanel their 3 members on night 1 of a public hearing, but maybe this goes through several meetings.
Somebody that,
And somebody drops
Yeah.
out for one reason or another. So you may not know on night 1 that by the time you're ready to make a decision, that one of your permanent members maybe, misses a meeting for whatever reason or misses 2 meetings, and now an associate has to fill in. So well, technically, that associate member, up until we know they're actually voting, is not necessarily considered a member for the purposes of your quorum. But since you don't necessarily know who's going to be voting, I think it would be a best practice to just say, we should not be discussing
better be
this
safe than sorry.
at all, exactly.
Another
Yes.
question, quorum. If a committee has an ex officio town official also sitting on the committee, they, and they're listed on it, are they part of the quorum? And, we're assuming they vote unless it's specifically in the bylaw that they don't vote.
I would say that if they're a voting member, and most ex officios are just providing advice, but some do vote. If they are a voting member of that board, they count towards the quorum. If they are simply there to provide advice and information to help inform the board's decision, if they don't vote, they would not count towards the quorum.
Thank you.
Thinking about it?
Yes, go.
Okay.
We need to get to deliberation.
I know.
You
You know what happens? I always get through about halfway and realize we've now covered everything by virtue of the conversation, so it'll be fine. Okay, I think we can advance to the next one. Thanks. So what is a deliberation? So this is the broad discussion, otherwise known as communication. It is an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. So there you have the very broad discussion. So, it used to be, I've been around long enough to remember, the days before email, when deliberation really would have to have just been people talking to each other or calling each other. Or maybe there was a memo that was distributed. But now we're dealing with email. And it's so easy to include everybody or do a full board blast. It's much too easy to hit the reply all button. We're on social media, we're on Facebook, we're in chat rooms, we're on blogs, whatever it happens to be. All of that technically is subject to the open meeting law if you have a quorum of your board participating in whatever that forum is. So we'll talk a little bit more about that. So we've got the next one.
So, well, yeah, you continue and then I'll ask questions.
No, okay. So I think I just covered that, but oh, wait, so one thing that the communication or deliberation excludes. In other words, these things, these final 3 bullet points that are there, this is basically what the open meeting law allows you to communicate with all of your board members and not violate the open meeting law. So you can distribute meeting agendas. Even if that meeting agenda happens to include like a packet of materials for your reading pleasure over the weekend prior to your meeting, you can distribute all of that. You could have a communication among a quorum of your board about scheduling. Gosh, it's really, the weather's gonna be bad on Wednesday night. I think we're gonna have to reschedule our meeting. Could you meet on Thursday? No, I can't meet on Thursday, but I could meet on Tuesday. Could you meet Tuesday at 5? No, I can meet Tuesday at 7. Doesn't matter if you've got all of your board members participating in that. If all you're talking about is scheduling, that's a perfectly acceptable form of communication. So the last one that's on there that I've highlighted, so
Wait,
long as.
procedural information would be,
So procedural information, it would be kind of the same thing is meeting materials, but or it might be not just scheduling a meeting for Tuesday night, it might also say, and we're going to have to take item number 4 out of order because the applicant has, or the department head, whoever it is, has informed us that they've got a conflict and have to go to the advisory committee that evening. So we're going to take something out of order. That would be fine to communicate with all of your board members. Then you can also distribute meeting materials, reports, any kind of documents. So if you happen to get, say, an appraisal on real estate, or you get a traffic assessment, or maybe you've had a feasibility study done of that school building project to see what exactly needs to be done, or are we talking about a repair or a complete, renovation of the building? All of that can be distributed by email, as long as no member expresses an opinion. And that is pretty broad. So that goes back to your prior comment, sir, about, well, what if I just point and say, well, that's where the roof is leaking? Great, that can be said. But if we then go into further detail about, when I was here 10 years ago and I did a walk through this building and the roof was leaking then, and you can now see that it's gone further and now it's, damaging perhaps the foundation or something. Stop at, look at the roof, the leaking roof, because anything beyond that starts to get into you're expressing an opinion. Maybe you're even starting to indicate to your other board members whether you might be in favor of or opposed to something. And that is all the type of communication that should be in an open meeting. So if we go to the next slide, please. We'll go one more. I thought there was a different one coming up. I'm sorry, Megan. Okay, we'll come back to that other one. So as I said, you can certainly email about availability for meetings or distribution of anything in a meeting packet, as long as you don't comment on it. So sending everything out and saying, here's all the materials for Tuesday night's meeting, it's perfectly fine. But if you say something such as, and I'd call your attention to the engineer's report on page 5, where the engineer suggests X, Y, Z, or as I look at this, there's no way in the world I could possibly support this project because doing anything like that now takes the distribution of the materials and converts it into, now you are expressing your opinion.
Well, the second piece was an opinion, but not the
Not
first
the first.
piece. First piece where you say, take note of paragraph X, period.
What does it? Because aren't you sort of tipping your hand a little bit to somebody to say, I'd like you all to pay attention to what's on page 22. Well, maybe there's something on page 15 that says just the opposite or supports a different position versus kind of indicating, look at page 22. You might be somebody might be able to infer from that there is something problematic on page 22 or something that is either going to make this something that we support or we reject based on that information.
So
So-
where would it be like, I mean, I feel like it's helpful to summarize some of this stuff, because it's like a lot of the things are lengthy documents that honestly are really snoozeful. And so I find it helpful if somebody can point me to the part
Yeah.
that's most
So,
relevant.
Especially if
But
you're
is
gonna
is there
speak-
a definition that has to do with the spirit of the law where it's clear that somebody was pointing out, this is where, if you get to page 2 and 3 is what you really need to read versus page 2 and 3 is what you need to read, and please don't look at page 5 and 7 where it says, yeah.
or even if you say, I draw your attention, the executive summary can be found at pages 33 to 35, something like that. You're not expressing an opinion. You're just kind
Okay,
of.
so you can use it as long as you're not using it
Yeah,
nefariously.
there's, it's like shades of gray, and what you might think is not expressing an opinion and what the Attorney General thinks is may vary a little bit. you mentioned summarizing information. Yes, it would be great to summarize information for your board members. But when you summarize information for your board members, you're deciding what you think is important or what should be highlighted.
Yeah.
And another board member may feel very differently about that. If you want something to be summarized so that folks have a more digestible document to read as opposed to a snoozer, the better thing to do would be to have a staff member provide that summary.
A town staff member.
Yes, yes, because you putting your name on it as chair or as a member of the board saying, you know, I took the liberty of going through this document and providing a helpful summary to folks. There, you run the risk that there is going to be something in there that is arguably an expression of opinion. And I should back up on all of this and say, this is what the law says. Now, nobody in Cohasset over the last 3 years has filed an open meeting law complaint about this. I'm not hoping to invite any complaints, but just because you do something, or perhaps just because you have gotten away with doing something, doesn't mean you're doing it right. It just, lucky you, as opposed, like I said, in other communities, these are the types of things that some people will pick up on and will file complaints about. So just be mindful of it, you're doing that.
On your example you're speaking about. Are you able to say something like, you know, here are all the documents for the meeting, and we will be discussing discussing page 22?
I think you could.
Okay,
Mhm.
again, no opinions, but you're saying that's what I want to talk about.
I think you
Okay.
could do that, yes, yep. So put at the end there, beware of reply all in emails. There used to be a strain of thought, or I'll even ask the question. If you as a board member email all of your other board members, but nobody responds, is it a violation of the open meeting law?
What are
Would
you
you-
emailing?
You're emailing them something of substance, not just, can you meet on Tuesday night?
Right.
Now, most people would fight with me about that and say, but nobody responded, therefore it doesn't
But
matter.
it's a one-way, it's one person expressing their opinion. of
It's
course they
still
did,
one
basically.
person expressing an opinion and going out to a forum of the board. So it's still a violation. It doesn't matter anymore if nobody responds.
This may be overly simplistic, but I'm sort of thinking that basically, if my statements could be understood by someone as having a particular bias or perspective, then that's when I need to think carefully.
Correct. Then it's definitely, if you're starting to wonder, is this showing bias or perspective, then it's clearly opinion. You know, this fuzzy category of procedural, you know, we're gonna be discussing page 22. I think that's procedural. I can't sit here and say that the Attorney General always agrees with me. But, you know, I've been doing this a long time and have pretty frequent conversations with the Attorney General's office that you start to get a sense of, you know, what they will, when they will agree with you and when they won't. But again, if nobody files a complaint, then consider yourselves lucky that you might just get, you know, dodge one. So we could go to the next one, please.
But that is the idea of the whole thing, is to avoid biasing your
Yes.
fellow board members before the open meeting.
Correct. We covered the first, so a couple of these throughout this presentation. Where you see like an OML 2015-77, these are actual decisions from the Attorney General that were applicable in the presentation. Put them in there. If you go online and you just search Mass Attorney General Division of Open Government, OML determinations, you can search by town and number and pull any of these up if you actually want to read it. Unfortunately, all you're reading is the determination, and sometimes you don't get the full facts of maybe what the original complaint said or what the town's response was, but you get enough of the flavor of the, you know, why the Attorney General either did or did not find a violation. So, you know, feel free to check some of these out if you're curious about them. So we were talking a moment ago about what can we summarize, and I mentioned, you know, a report, and I said, you know, you could have a member of staff summarize. But I've also put in here, so a member of the staff, so let's just say the planning director wants to email everything to the planning board members relative to their meeting next week. That's, the planning director is not subject to the open meeting law. The planning director can email the entire board and provide all of that information. It doesn't have to come from another board member. The planning director can also email maybe a technical review or summary of the applications. So similar to, you know, condensing this or preparing a summary for your other board members. A staff member can provide the staff members summary or analysis to the board. I mean, this is one of those things we tend to expect of our board members, I mean, our staff members, that they are going to provide us with that technical support. But you can't use a staff member to circumvent the open meeting law. And so what do I mean by that? Well, we all know that there can't be a communication among a quorum of the board. So if you've got a 3-member board, for example, and let's suppose the chair of the board calls the planning director and is talking about the project. That's perfectly fine. They're not a quorum of the board. That's not an open meeting law violation. But now a second member of the board also calls the planning director to talk about that same project
Separately.
separately. If it was together, it's definitely a violation because now we've got a quorum of the board. But now we have a separate conversation with a second board member. And if the staff member says, well, I was just speaking with the chair earlier today, and the chair has indicated that, you know, he or she really has a problem with X, Y, and Z, or the chair has indicated that they just can't support this project because of blah, blah, blah. The staff member is now being used as the conduit to convey one board member's opinion to another board member, and it's a 3-member board, so we've now got a quorum, so we have a violation. It's also considered a serial communication, that folks used to think, well, if it's just 2 board members communicating, there's no violation. Well, that's true. But at some point, if A emails B and B calls C and C runs into D, you know, at the soccer field, we've now got 4 members of a board that all know or have all been part or privy to this same communication being shared. So those are difficult to catch and to prove. Because unless somebody is following and surveying your emails, which is a little difficult to do, but you know, there are times, for example, where it becomes sort of obvious in your meetings that there has been some kind of communication. And I'll give you a real life conversation that I had with an attorney representing a particular applicant, not in Cohasset, who called to tell me that, well, she's been told that 2 members of the board cannot support this project because X, Y, and Z. And her first comment to me was, I'm not suggesting that there's been an open meeting law violation or anything, but how are those opinions being communicated? And of course, I know nothing about it because nobody tells me, but it is a problem. There is a perception if you suddenly find yourself going to the meeting and maybe a comment you happen there, the way you phrase something, or one member says, well, Joe, you remember when we were talking about this last week? Oh, really? You were talking about this last week? The board didn't have a meeting last week. So how were you discussing it last week? It tends to come to light one way or another. So be careful of
But
any
again,
communications like
that's
that.
with 2 people, not the quorum. I mean, unless the quorum happens to be two.
Right, but even serial communications that add up to a quorum
Okay,
is a
okay.
violation. So like I said, A to B and B to C and C to D, now you've got a quorum. Even though it might only have been two members at any given time. Once you get to a quorum that have all had the same bit of information shared with them, it's a violation. Okay. We already covered that second one, so we can go on to the next slide. So social media, this I think is probably something that is the most challenging for board members today because people want to be on social media, people are getting their information that way. They find it's easier to communicate with a whole bunch of folks. The best piece of advice I can give you is remember that even social media could possibly become a forum outside of a public meeting where you are communicating with a quorum of your board. It may not always be quite so obvious because maybe not everybody uses their name when they log in, or sometimes someone might show up as, say, their spouse, if they're using a spouse's device or account. Or again, it could be a serial situation where one board member is reading something about a controversial item. And one board member feels compelled to jump into the conversation because it's full of misinformation and we want to set the record straight, right? Well, if there are two other members or three other members of your board that are all part of this string or part of this group chat, whatever it might be, you might not even know that you're communicating with a quorum of your board when you do that. My piece of advice to folks is stay off social media when it comes to town business. It's one thing to say a tree limb is down and this road is closed and you're letting people know about a public safety matter. Or you're letting them know, please, there's going to be, town meeting is on Monday night. We really would like to see you all show up. But when you start getting into really the weeds of any particular matter, the best advice I could give is if you can't resist the temptation to just stay away and not jump in, then jump in and say something like, I'm really glad to see there's so much interest in this particular matter. I would invite all of you to come to Wilcott Commons on Tuesday night at 7 o'clock when there will be a public forum to discuss this. And we'd really love the opportunity to, engage with you at that time. That's fine. But don't start getting into the project is not going to cost 10 million. The project's only going to cost 5 million. The amount of the grant was 7 million. And don't get into that because now you're starting to get into something that should just be discussed within the confines of your public meeting. Go to the next one. And this is just the Attorney General weighing in saying how they strongly advise against using social media groups for precisely this reason. Go to the next one. So meetings, we know that a meeting obviously is a forum of a public body coming together to discuss some business. We'll go through your posting requirements, which I don't know if anybody online happens to be a staff member that would actually be in charge of posting meetings. I'm assuming we do have some either chairs or clerks of boards here that might be involved in preparing your meeting notices. Yes, no?
No.
Some, yes, okay. All right then. The open meeting law requires obviously that we post all of our meetings 48 hours in advance, and I will talk a little bit more about that in a moment. But one of the things that we also have to bear in mind is the meeting notice has to give what board, the date, the time, and the place of your meeting. And it must list everything that you expect or that the chair reasonably anticipates will be discussed. And it has to be detailed with sufficient specificity so that somebody sitting at home who says, gee, I wonder what the Affordable Housing Trust is up to this week, they can hop online and they can look at your agenda and see, oh, they aren't going to be discussing One Pleasant Street. I don't need to go because that's really the only project I'm interested in. You also have to bear in mind that your meeting and your location, it has to include if you're doing Zoom, and I know it's a little bit of a mix here right now as to what boards are meeting in person or via Zoom. If you're meeting in person, you have to say the name of the room. So what are we in? The sail loft room, okay? If you were meeting via Zoom or whatever other platform you might happen to use, you've got to put the Zoom link and whatever the code is on your agenda as well. If it's a hybrid, put that it's a hybrid. So if people want to come in person or if people want to participate by Zoom, then we've got to have both the physical location and the Zoom location identified on the agenda. Another thing to bear in mind is that your meetings have to be accessible for folks. This is a requirement of the open meeting law as well as the Americans with Disabilities Act. So, for example, if you happen to know that you might have somebody who is hearing impaired, or maybe someone has a mobility challenge that will be attending your meeting. So for example, tonight, we all able-bodied folks came up that flight of stairs. But if there were someone who has, is in a wheelchair who is not able to come up those stairs, we would have to move the meeting location downstairs to wherever it's accessible. It's also important to bear in mind.
We have an elevator.
As I said, I have actually been I have been to a town hall where, when the elevator is broken, and it's, well, that's a problem, isn't it? If the elevator's working, not a problem, meet upstairs all you want. If somebody, as I said, is hearing impaired, if there's a way that we can provide amplification of the sound or maybe closed captioning, whatever it is. One of the things board members will say to me is, well, how do I know? But you're right, fair point. We aren't required to provide all of these things in anticipation of someone who might show up. We are, however, required that if we know, or if we then become aware that somebody has some sort of disability, if there's a way that we can meet whatever challenge it is, we do have an obligation to provide microphones, provide closed captioning, move the meeting downstairs, if that would make it more accessible. For those who do, we were talking earlier about site visits. Bear this in mind too. If you decide that you're going to post a meeting to go to One Pleasant Street to walk the site and figure out whether or not we should purchase that property, that's perfectly fine to do so. You can post a meeting there. But every time you post a meeting, you are posting a public meeting, which means the public is allowed and has a right to attend. So do we own One Pleasant Street? No, we do not. Do we have the permission of the property owner to have a public meeting on their private property? I've been in some meetings where a board will say, we'd really like to come and walk the site and get the lay of the land. And the property owner will say, sure, the board's welcome to come anytime you want. Saturday morning, 9 o'clock, I'll have coffee for you all, we'll be there. But I don't want my neighbor from across the street coming, because I know my neighbor is opposed to this project. Then we can't have a meeting at that site. We could still have a site visit and nobody deliberate, but we can't have a meeting because the meeting has to be accessible to folks. I went on a site visit once that had to do with an earth removal project where a pretty significant hill was being cut into and earth was being removed. And the earth removal board wanted to go and get an assessment of exactly how many cubic yards had already been removed from the site. And a board member shows up on crutches because they had just had some kind of surgery or something like that. But the board member can't even walk far enough onto this site to really be able to assess the situation. So think about that when you're thinking about where you have meetings. I've had town halls where the elevator is broken and they have to post a sign. The meeting has been moved downstairs because the elevator is broken.
Can I just ask a question?
Sure.
Question, you said that only if you're anticipating that somebody is coming that needs a special accommodation, or?
Right, if you happen to know.
So it's not, you don't have to prepare as if.
Correct. So usually it would be nice if we know in advance, but. And that's not always
Well,
the
it'd be nice if
case.
we all did it all the time, so that
Right.
everybody always felt like they could show up and didn't have to. worry
Right,
about stuff.
you know, the important thing is that once you're aware that there's some kind of situation that has to be addressed. Can we address it right then and there? If we can't address it. The best course of action then would be, okay, we're going to reschedule this meeting, or maybe reschedule the discussion on the particular item that the person might be attending for to another day or another location, when we can have the technology we need in place, or we can have a working elevator, or we can have a room on the first floor, whatever it happens to be. I mean, ideally, you'd like someone to reach out to the board or staff prior to the meeting to say someone who is blind, or somebody who has a hearing impairment will be attending your meeting next week. Are you able to provide X, Y, or Z so that they can participate in the meeting? If they show up 5 minutes before your meeting starts, you don't really have the opportunity to prepare for that. So that's one, just gotta think about, well, what reasonable accommodation can we make so they can participate? And if we can't make anything that night, see if you can reschedule the meeting to a time when maybe we could get something in place. Sometimes folks have said to me, oh, we posted a meeting, so for the sail loft room. And we've got somebody who can't come up the stairs, the elevator is not working. It's perfectly fine to move your meeting location. You have to just post, if the meeting was to take place in this room, my recommendation would be you post something at the doorway to this room. And I would also posted something downstairs where you had the sign that said open meeting law with the arrow. My suggestion would be to say open meeting law training has been moved to whatever other, room on the first floor, if that's the case. That's perfectly fine. Do not close and lock the door during open sessions. This might seem like something that is a no-brainer. But lots of school committees meet in schools. And now, because of school security, doors lock. And there was actually an open meeting law violation found with respect to a meeting that took place in a school. And the doors were locked. And I think they had someone who was like monitoring the door and allowing people in. But that person had to leave at, a set time, and the meeting went longer. So it was found to be an open meeting law violation, because as long as that meeting is going on, anybody should have a right to have access to get in. People will sometimes say to me, you might even hear this at some of your board meetings, keep that door open. The best practice would be, yes, keep the door open so that folks know that they are welcome to come in and join your meeting or listen in. But as long as it's not locked and they are able to come in, or maybe there's a sign that says, welcome, please come on in. That's fine. You don't have to keep the door open. The last thing on there has to do with, or the last two have to do with, like remote meetings and passwords. When we first started with remote meetings during COVID. I don't know if any of you remember or remember Zoom bombings that were taking place. Those were things that have settled down, thankfully. So in response to some of the Zoom bombings, where an uninvited guest would unexpectedly enter your room with terribly inappropriate material or visuals. In response to that, some communities start saying, well, we're going to put a password so that you can't actually access the meeting unless you have the password. And even early on, folks were saying you have to call somebody at town hall to get the password. so that we make sure only people who are supposed to be there would have that password. We can't require, or we can't keep the passwords secret anymore. We've got to put the passwords right on, the meeting notices. Or you've got to have them somehow readily available to folks. So a lot of, your meetings, you actually do them in the form of a webinar, at least the ones I've attended. So you have to be promoted to a panelist. So that there is somebody like Megan who is making sure, there might be, 50 people out there right now who are listening in or watching, but they aren't all allowed to just speak unless they were elevated to a panelist. That's one way that you kind of get around the Zoom bombing, although I don't hear about that happening much anymore, so. If you have a glitch in your technology, then as soon as you are aware of whatever that glitch is, you are supposed to pause your meeting and immediately address the technology issue. So if it is that we've all suddenly frozen, or the internet access has suddenly gone down because of a storm or something like that. If you're able to reestablish the meeting, say within a reasonable amount of time, that's fine, you can do that. If it appears, say after whatever you think is appropriate, 5 or 10 minutes, that we're not going to get power back, or we're not going to get this back up and running tonight, then the best practice would be just adjourn your meeting and stop your discussion of business wherever the technology glitch occurred. Pick that up at your next meeting.
Oh, question for you.
Sure.
What if the glitch is not, the cause being caused by this group, with somebody in the chat room who wants to get promoted and all of a sudden they go blank? It's not our technology, something's gone wrong at their end.
Mhm.
Does that require a board to then suspend?
If it was unique to just one person, I would say no. If you suddenly notice that, if you had an audience of maybe, 5 or 6 people, and all of a sudden, everybody is
They're all
lost. That's usually an indication, oops,
It's
something
probably-
has
It's
happened.
probably here.
Or probably, but one person who is, driving home and they've logged in, or they're, participating by phone as they drive. And then they go through a tunnel and lose connectivity, that's not really a technology glitch on our part.
Right.
What I have seen happen is just that. That sometimes whatever the Zoom link is that is posted on the meeting notice, we all go to log in. And it's not working, or, and then you start to see the emails being exchanged. Can somebody send me the Zoom link? This doesn't seem to be working. You could then immediately post a new Zoom link. That's not going to necessarily be the most effective way, but it's the only thing you can do once the meeting has begun, right? And you hope that other people out there hop on the website, look at the meeting notice, see that it was just updated 5 minutes ago with a new Zoom link, and hope that you haven't missed out much on the discussion.
And when you say post, you mean post to the town website, or post by email to the members of the committee?
You would have to actually post it to the town's website, because it's all well and good for you to share the new Zoom link with your board members. But the public
Should have
also
access,
needs to
yeah.
have, so somehow that has to be communicated. And the best way to usually do it is to go into the calendar, and if you're able to update the meeting notice.
So our town clerk does all of our postings, and I believe, I don't know if that's a part of our bylaw or the law, but I know that only the clerk can post in Cohasset. Because there's certain other procedural things that need to be done. So that would be tricky in that scenario, and just fingers crossed that the town clerk is on her email and.
But for this time of
Yeah.
night,
Right,
that letter.
yeah.
Right.
Yeah.
Unless somebody's got the town clerk's cell phone, and she's gracious enough to pick up after hours. You're right, you might simply be out of luck. Or maybe think about another way of doing that.
Another thing, let's say it's this meeting. We've been going for an hour and nobody's on Zoom. And then you have the power outage.
Mhm.
Can't you just keep going?
If you're not aware of there being any,
Well, no, you know who's on Zoom during the meeting. And if nobody was on Zoom for the whole meeting.
so like right now, there's
Right.
nobody out there, it's just us. And the internet goes down. We could still continue. the
Okay.
meeting. Cause it isn't about us denying anybody access. I suppose there's always the possibility that somebody tries to log in at 8:30 after they were done helping their kids with, homework and dinner, but
Okay.
we can't be responsible for all of that, can we?
There's still the in-person option.
That's true, they could come run on down if they want to, right?
Based on what Megan said, that only the clerk can do a posting. What should we do then if we can't contact the folks? Clerk?
Then your option would be to reschedule the meeting. I mean, if you're in person,
Mhm.
but there was a hybrid option for folks. As you were just saying, folks could still come on down and attend in person. But if we know that the Zoom link is not working and we can't restore that, or there's a power outage or whatever it is, and we can't get that information out, the best thing would be to just reschedule your meeting. Yeah, yes.
As a nerdy question, if you, most of the content is not visual, most of the content is audio. So if if the Zoom link goes down, can you, and you know the numbers of the people that have been on the Zoom, can you reach out and connect to them by phone and have them participate by phone?
You could, or they could, oftentimes, they're given the video option and or just the phone option. So you're right, you might lose somebody on Zoom, but they're still, calling in. You could do that.
I just try to accommodate,
You could, yes, I've actually,
because not accommodating sounds like a huge waste of time and unlikely to be resolved until like a whole month and a half has passed. And
The
we're ready to
only-
schedule the
yeah.
next meeting.
right, it is, absolutely. The only
So
problem is,
sure.
sometimes you just get people who don't give a name, don't give an email, don't give a cell phone number. I was on a meeting earlier today where with caller number 1 and caller number 2. And the board said, I'd like caller number 1 and caller number 2 to please identify themselves. Not that we would have had a way to get back in touch with caller 1 and 2 if the meeting went down, but what do you do in that situation where you knew there were people who were listening in? Technology fails you, and you don't have any way of reaching out to them short of putting something immediately up on your website to say, the meeting, the meeting link just failed. Please try this link. You could try that.
I mean, maybe there should be a phone number that you announce at the beginning of each meeting and say, if anyone has tech questions, call Susan.
Exactly, or something should happen,
And
you
then
know,
it's
our-
there, and then you have an option.
right, that
Maybe
there's
that's a
somebody.
policy we should all
There's
put.
somebody like perhaps like a Megan at all of your meetings who is keeping their eye to make sure, yep, everything's still up and running. Or if somebody has lost connection for one reason or another, they can then call Megan and figure out how they can get back into the meeting one way or another. That would be perfect.
Well, we had a situation, I don't know, a couple of town meetings ago, in the middle of the town meeting, the Zoom died. And it probably was off for about an hour. Should they have shut down that meeting? Again, this is a town meeting, an annual town meeting.
There was an annual town meeting by Zoom?
Yeah, I'd say in the last, I can't remember, September, October. No, it was this, within 2 years. So they lost connection for at least a half hour. But it seems, according to this, it seems they should have shut down the meeting.
Yes, they should have. I'm gonna say, I don't remember.
Let me get
town
the
meeting
Attorney
Zoom.
General's name.
Are we involving in this? Like,
Streaming, so people go watch.
So people could watch, well, that's different.
That's different,
That's
yeah.
different.
Why is it
Yeah.
different?
Because I was just saying, the 3 years I've been covering the town meetings, there's been no Zoom, but this gentleman just suggested that they might have been actually streaming it so that people at home could watch,
Right,
which they do.
But they can't participate live.
Right, they're not there as voting
oh,
members.
okay,
So,
okay, it's an audience as opposed to
yes,
a
yes.
participant, all right.
But is
Yeah.
that changing?
Sorry,
Is that changing?
what changed?
That town meetings will be able to be participated in?
not
Did we have
yet.
a, I thought we had.
Oh, yes,
We did, but
there has
we're
been
way
special
off on that.
legislation. Legislature's not acting on them. There's been at least 3 towns that have filed, or maybe 5, 6 that have filed for special legislation to allow for Zoom town meetings. You can do it if you're a representative town meeting, but not an open town meeting. And even then, if you want to see a representative town meeting with, say, 252 members by Zoom, chaos. Really, I would much rather have everybody in the gym. Okay, I think we're done with this particular slide, Megan, thank you. All right, we have covered that, both of those.
I used to have a lot of meetings, for my job, and when we posted an agenda, we say, if you need special accommodation, please call. our
That's a
office
fabulous idea.
24 hours in advance.
That's a great idea.
Because that covers both, that covers disabilities and technical disabilities, which might be more common.
Or even just people who show up and say, gee, I wanted to do a PowerPoint presentation. Do you have a projector? Do you have a laptop? Whatever. You know, that would all be nice to know in advance, right? So, yeah, no, I think that's a great idea. So the timing of the meeting notice, you should all know that you have to post it 48 hours in advance. It does not include Saturdays, Sundays, and legal holidays. So Monday holidays always trip people up because they always forget to post their meetings on Thursday for a Tuesday night meeting. So be mindful of that. Emergencies, in the event of an emergency, you can dispense with the 48 hours notice and post as soon as possible. Whether that's an hour or 2 hours before, whatever you possibly can accommodate. You know, and what is an emergency? It really has to be a true emergency. It has to be, you know, a sudden, unexpected situation that requires some kind of immediate action. So, you know, on a night like tonight, you can find out that there's road closures and tree limbs down and power outages and maybe a big sinkhole or something like that. And that requires, you know, a Board of Public Works to suddenly get together and authorize some immediate work to be done if necessary. That would truly be an emergency. Forgetting to post is not an emergency. And if you do post an emergency meeting, you are still required to comply with all of the requirements of the open meeting law in terms of taking minutes. And you are also supposed to limit your discussion to whatever the emergency is. So if we're here to discuss the fact that there's been a water main break, that's not the time to talk about whether or not we need to buy a new piece of equipment for the DPW. Next one, please. I think I've covered all of that. So one other thought. If you do have to have an emergency meeting as a best practice, we often will suggest that, okay, go ahead, post the emergency meeting, do what you have to do. I mean, COVID was a perfect example of this. We were oftentimes suspending a lot of rules just because we were just in new territory and you've got to deal with it, and you've got to deal with it now. But we would frequently say to boards, okay, post your meeting as an emergency. But while you're doing it, also post another meeting 48 hours out. And the purpose for that would be, in the event that someone challenges whether or not your emergency was truly an emergency, or whether or not the authorization to spend some money or enter into a contract or do whatever it was that you did in that emergency meeting, in the event that that gets challenged in any way, if you posted that other meeting 48 hours out, you can put on that agenda that you're going to ratify the votes that you took at your emergency meeting. So, you know, your emergency meeting, you might not, because it's an emergency, you might not have been able to get any public participation, for example. Well, now the public can show up 48 hours later at that other meeting. They can at least maybe express some of their concerns or questions about why you did what you did. And the board can simply vote to ratify any votes that it took. And that in effect cures any problems with that emergency that might exist.
Why the 48 hours?
Because you have to post a meeting 48 hours in advance.
No, what I
unless
mean
it's
is,
an
why couldn't you
emergency.
say the next monthly meeting instead of 48 hours?
You could, but maybe you don't have the time, you know, maybe that would be too long. So for example, if you are authorizing, let's say we're going to, suspend certain provisions of compliance with our bylaw relative to, procuring a particular service. And we're just going to go ahead and we're gonna hire a contractor because we need a contractor on site in 2 hours. You might not want to wait until your next monthly meeting. Because if anyone is going to question whether or not you properly entered into a contract with that contractor, you might want to ratify that sooner rather than later. Doesn't always happen, but it's just a best practice. Yep. These are just two decisions, giving you some examples of what has been held to either constitute an emergency. Usually, you know, unexpected inclement weather, or I always like the other one where a one-day liquor license had to be issued for a wedding that was taking place the next day, and the wedding venue, I think was suddenly, you know, no longer available for some reason. Some might say that wasn't necessarily an emergency, but the Attorney General agreed that it was, so. We go to the next slide, please. We talked about the 48 hours. Talked about the fact that the meeting notice has to include the date, time, and place of the meeting. Revising meeting notices. I got a lot of questions about that. You are allowed to revise a meeting notice once it is posted. It does not have to be 48 hours prior. So think of it this way, once you post the meeting and you're at least 48 hours out, that meeting is legally going to go forward. Let's say your agenda lists 4 items. And then sometime between when you posted the meeting and when the meeting's actually going to occur, someone brings something else to your attention. You say, oh, well, let's add it to the agenda. You are allowed to amend that agenda as many times as you want, up to when the meeting actually begins. So the 48-hour notice rule doesn't apply to late additions, so to speak.
Well, but on that in particular, I would imagine that that's something that's said at the beginning of the meeting, to say we're gonna add an agenda item.
So you could also do that. I think if
Okay.
we go to the next slide, that might be where we discuss that. No, probably the next one, but that's okay. So the law requires the chair to include on the meeting notice anything that the topics that the chair reasonably anticipates 48 hours in advance. And that I've actually had the Attorney General call me to speak with a chair of a board directly to ask the chair, did you really not anticipate that this conversation would come up 48 hours in advance? I've only had that happen once, and it astounded me that they asked that question, as opposed to just take my word for it. I had no idea that someone was going to bring up this other topic, but it has happened. So what happens when something else comes up? So to your point, sir, matters that aren't reasonably anticipated 48 hours in advance can still be discussed and can be acted upon. So let's suppose, for example, you have a meeting going on and all of a sudden there is a deadline to submit a grant application or a deadline to do something before, you know, the bid is going to lapse and no longer be good. Someone could argue that we probably should have or could have reasonably anticipated that 48 hours in advance. And somebody could argue, well, it's not on the agenda, so you shouldn't discuss it. Well, both of those statements are technically true. But you can still discuss something that comes up after the meeting notice has been posted, or even during the meeting. You know, I've actually been at a meeting where a department head will suddenly say, oh, and here's one more thing that's sort of time sensitive that I would like the board to just take a vote on. Well, the fact that it's not on the agenda doesn't mean you can't discuss it. The best practice, of course, would be if it's not an emergency and you can put it off to your next scheduled meeting, or you could schedule another meeting to take up that, you know, sort of emergency matter. That's what would be recommended. But if there's a deadline where you're suddenly going to, perhaps, if we don't sign this tonight and get this in, we're gonna forfeit a $10 million grant from the state. I'd say, the heck with your agenda, sign that grant application and do what needs to be done, secure the $10 million and worry about the open meeting law complaint that may or may not be filed. So, you know, use your judgment. If it's something that absolutely has to be taken up that night and it's time sensitive, feel free to go ahead and act on it. If it is something that could wait to a later date, then it's recommended you put it off.
So just to clarify on that, so if it's something that doesn't need to be voted on, can you discuss something that doesn't need to action, but it needs discussion?
Yep.
So that.
Because not all the matters on your agenda require a vote, right?
Right, most of ours don't seem to, so.
Well, good evening.
um,
So it doesn't have to be something that requires a vote. It could just be something that requires a discussion. The only question becomes, okay, is there something that is a time-sensitive discussion versus a time-sensitive vote or a time-sensitive like signature to authorize something? You know, if we're just providing an update on something, it may not be as necessary to take it up that night as opposed to saying, you know, that is a great, you know, really appreciate you bringing that to our attention. We'd like to actually put that on the agenda for next week.
As a
And,
discussion.
you know, as a discussion point. Okay, we've covered all of that. Thank you. This is one that gets a little bit tricky. So I said earlier that the meeting notice not only does it have to include whatever you reasonably anticipate will be discussed, but it has to provide sufficient specificity. So I see this on agendas all the time. Town managers report. Financial update. Old business, new business. Those are not sufficiently specific. If you were sitting at home and you looked at an agenda that said, we're gonna discuss old business, we're gonna discuss new business, and we're gonna hear the town manager's report, would you have any idea what's gonna be discussed that night? No. So to the extent that you can provide some details surrounding it. You know, if the old business is, you know, something that was from a prior meeting and you're going to continue the discussion tonight, you could call it old business. But if it's a discussion about, you know, a liquor license, put down continued liquor license hearing for the Red Lion Inn. If it is the town manager's report, the town manager's report could include any number of things. Put some bullet points down that we're going to discuss town meeting articles. We're going to discuss, you know, the parameters for collective bargaining with the unions. We're going to discuss, you know, snow plowing this winter, whatever it is, put some information down. One of the things that, you know, one of the open meeting law violations that sticks in my mind under this one is, one particular town, and this is 'tis the season for license renewals. You know, December 31st, a lot of licenses expire and have to be renewed. So you will often see an agenda that will say renewal of liquor licenses. Well, one particular board had just posted that on their agenda. And someone filed an open meeting law complaint, and the Attorney General said that was not sufficiently specific. You should have at a minimum have listed the addresses where those licenses were being exercised. Maybe you even give like the name of a business or something like that. But just anything that is just more of a general category should be avoided and should include some kind of little bit more detail around it.
So in that one, can I be specific?
Go for it.
So we have reports from the harbor master.
Mhm.
I don't know what she's gonna say. I don't know how her week, her month has been. But she's gonna report to us on the state of the harbor, and that informs us of things that we need to know. So I feel like if we put harbor master's report on our agenda, we're not putting words in her mouth. And
Well, true.
we don't know what she's gonna report on.
Well, to the extent that
That's
you
why she
could,
reports.
yes, understood. Well,
Otherwise she'd be.
well, she reports, but also it isn't just to report to the board, it's also to get more information out generally, right? So what stops the chair from reaching out to the harbor master and saying, okay, so what will your report consist of? You know, are we going to talk about mooring permits? Are we going to talk about, dredging? Are we going to talk about maybe some responses to public safety incidents? It doesn't have to be an all-inclusive list, but I imagine that after a certain period of time, that the harbor master's reports tend to have some common threads to them of things that are reported upon. There might sometimes be some new items, like, the harbor master needs a new boat. So now maybe we're talking about, a capital budget matter for an upcoming town meeting or something. If you can provide some kind of idea, because maybe there's someone sitting at home who really wants to know when we're gonna get that poor harbor master a new boat, or wants to come on down and express, their support for something. It's the best
I mean, I think
practice.
That's more like a petition. I think the stuff that is always a surprise is the actual report. That, I wouldn't call that a report. I would call that a request. But a report is like, here's what happened in the harbor. We had a crisis and we needed to collaborate with people.
Mhm.
We don't know what that report's gonna consist of it, but it informs us and enables us to do a better job
Mhm.
of contemplating the right actions to be taken.
But are you
don't know.
talking about a report you get every month, it changes every month?
Yeah, it's like a
So-
standard part of our
So I
agenda.
don't
that she
think you can
reports
say
to us.
any more than the harbor master's report. Cause I think that's it changes every month.
Well, like I said, if there are certain things that there are common threads, if there are responses for service or, some certain things that the numbers might change each month, but there are some common themes that are reported on by the harbor master. If you can put some of those down, that's what would be preferred. If it's, like I said, you don't get open meeting law complaints here, so you've been getting away with saying, reporting the harbor master.
I'd like to know how to
you know,
do it right, and I'd like to know how to make
Right,
this functional, and I would like to know how to make it so that, meetings are tolerable to sit through, and everyone is included and has access to all the information and can participate.
Well, let me also
But
ask
can't you
this.
speak to the harbor master in sufficient time ahead of the meeting so that you can comply with the 48-hour notice?
But then it becomes, one person is speaking, one of the board members is speaking to the harbor master, and that seems much
No, you're
less.
reporting.
Oh, no, that's
to me.
allowed, just.
But
to
how do
get the
we know
agenda.
that person hasn't influenced with the agenda and narrowed it down right there? I mean, I'm not saying this has happened,
Mhm.
but I'm wondering, like, because I actually have a question, but you don't have to take it now, you could take it at the end. About what is a good way to get something on an agenda? If you're not the chair,
If you're not the chair.
yeah, because you
Well-
can't discuss it.
No,
But
but you can, so let's go back to.
you can keep going and then come back to that if you want.
Well, we're here, so we'll just. So you can reach out to your harbor master when you're setting the agenda to say, give me some highlights of your meeting so that I can put something on the agenda. You know, are we going to be talking about the replacement of the town landing? Are we gonna be talking about dredging? Just so that topics that people would be interested in, they might tune in or appear for your meeting. Do you get the harbor master's report in writing prior to your meeting? Or is it just delivered at your meeting verbally?
I don't know, I just
Okay.
hear, I mean, I'm not the chair.
Because I was gonna say, you know, if you get the harbor master's report in writing,
Imagine she would enjoy doing.
and if it's then, and if you're in the practice of sending out your materials to all board members, you know, before the meeting, if you put all of those materials online so that members of the public could also see not just what you'll discuss, but they can also see the detail behind it,
Hmm.
then that might actually be one way around, okay, maybe we didn't give you the detail about the harbor master's report, but if you look to the next page was the harbor master's report. So that's one way. How do you get something on the agenda if you're not the chair? If the board has adopted any kind of internal procedures, then I'd say you have to consult that. I don't know of any specifically off the top of my head, but periodically, some boards, like a select board in particular, might adopt some rules of procedure. But there is nothing that stops any board member from requesting something be placed on an agenda. Whether that is a phone call from that member to the chair or an email from that member to the chair. Simply requesting, I'd like to discuss the dredging project. That's fine. Some board members will also do it in the context of the meeting, where a discussion is taking place, and then suddenly one board member says, you know, Madam Chair, I would just like to request that we have a broader discussion about this topic perhaps we could have it at our January meeting, or something like that. Sometimes there might even be a vote of the board where maybe somebody, if maybe you feel you have to make a motion to have a certain topic placed on an agenda. This is a little bit of an exception rather than the rule, because in my experience, most chairs are perfectly willing to put something on an agenda that another board member has requested. But every once in a while, there might be some conflict of sorts, or there might be, maybe this is something that the chair, for various reasons, has not wanted to discuss publicly. Well, you as a board member can force the chair's hand. Make a motion. I want to see a full report from the harbor master. And have a discussion of this item at our meeting in either January or February. Hopefully you've got a colleague on the board who will second it. And if you've got a majority of the board members to vote to place that item on an upcoming agenda, the chair's gonna have no choice. And if the chair doesn't put it on the agenda, you know what the board members do? They bring that up at every single meeting until the chair finally does put it on the agenda. And you wear them down that way, but hopefully. Oh,
Question on.
Oh, sure.
On Zoom. Lee, I'm gonna allow you to talk. One moment, please.
Don't make me write a report.
Good evening. I have a question. You said that if you have a line that just says financials, it should be expanded on an agenda?
yes, to the extent that you can. So if it is something, for example, like proposed operating budget or capital plan update. Nobody is expecting that you're going to put a financial report that gives you the current account balance of, you know, every line item that's within a particular department's purview. But something that gives the public a sense of, are we just talking about our revenues up, our revenues down? Are we going to need a Proposition 2.5 override? You know, are we kind of operating within our budget? Are we going to need a supplemental budget request? Something that just gives the public an idea of what does this mean? You're talking about, financial report. What kind of financial report?
Unfortunately, we have not been getting very good financial reports from the town like we used to, since the town manager has deemed that the required monthly reports of the state and the town bylaws are unnecessary, that we don't even know if someone from the town is ever going to show up at our meetings like they used to. But we are in sort of a situation where we don't know a lot of what we have. And we hope that eventually someone from the town will show up and give us some information.
Well, duly noted, but with all due respect, this is about when you actually have a topic for discussion on your meeting. Not really getting into who should
Yeah.
be providing what information or whatever the case may be, but
No, well, we do discuss financials as we can because we have our paid services from our engineering company, and they give us what they have for our expenses, so we know that, but we are a little shaky on some income and other information that we had normally been given from the town. And I know we are looking now at a lot of large ticket items that have to come up. And we just basically put a financial line item in, but we discuss finances within other topics of our agenda. Is that acceptable?
if you're talking about finances in the context of other projects, like how much is this project costing? Are we 50% done? Are we over budget, under budget? That's fine. Your better way to describe that for purposes of the agenda would be update regarding, the Bound Brook project or whatever it happens to be. You don't have to necessarily say financial update. It would, but that might be part of the update on the project. Does
No,
that
well,
answer-
historically, in our agendas, financial was always the town coming in, giving us updates and telling us exactly where we were. And we've just kind of left that agenda item that way in the hopes that we'd be returning to it once the town stabilizes with their current situation.
Understood. Okay. Is there
Thank you.
one- You're welcome. So did you have another question?
No,
You're
thank
good.
you.
Okay. Okay, I think that we've covered that slide. So executive sessions, so the opposite of obviously having an open session is executive session. And executive sessions are governed by General Law, Chapter 30A, Section 21A. And there are very specific reasons listed there as to what are the purposes for which a board may go into executive session. You still post or include the executive session on your agenda, the same way you would any other topic. And depending upon the purpose of the executive session, there's maybe varying levels of detail that the meeting notice might require. So for example, if one of the reasons you can go into executive session is to collectively bargain with your unions, or if you're hiring, say, non-union personnel, you are required, if you're going into executive session for either of those purposes, to also include the name or names of the union or the name of the position with whom you might be, a non-union position that you might be negotiating with.
Let me just ask a question. I have seen in some agendas, not so much ours, but going into executive session for the purpose of pending litigation or likely litigation, you have to say regarding
Yes.
222
Yes.
Jerusalem Road or
And-
whatever it is. I
yes.
hope nobody else.
Or
does.
exactly, or even more so, I when I draft those executive session language for agendas, I'll actually reference the actual case name, the docket number, the court that it's in. And if it's not something that is readily apparent to people, like I'll pick on one that was JAK LLC versus the planning board. Well, would anybody know what that pertains to? No. So I would then put on the agenda regarding 70 Black Horse Lane so that folks have some context about what it is. That's all perfectly fine to do it that way. If we go to the next page, we get a little more detail. So I did not necessarily list every single purpose for going into executive session. Because that could be another hour of discussion on its own. But I highlighted a few here that I think are probably the more common ones that we deal with. One thing that you always have to remember is the board has to convene in open session first, always. Even if the only thing that you have on the agenda that night is having an executive session, you open your meeting in open session. You then have to have a vote to go into executive session. And your vote has to basically follow the language of the meeting notice, if I've prepared it. So you've got to read all of that information that we're going into executive session pursuant to General Law, Chapter 30A, Section 21A, purpose number, we'll say purpose number 6, to discuss the value of real estate and whatever the address may be, because maybe we're considering buying or selling property. That every motion to go into executive session and every motion once you are in executive session requires a roll call vote of the board members. If you're going to adjourn from executive session, meaning you're not going to come back into the open session, you should announce to folks right then and there that, the board will not be reconvening an open session. So, again, back in the good old days when we used to meet in person in meetings, the board going into executive session would open their meeting in a room like this. They would then go to a side room somewhere for the executive session, and there would always be people sitting out here, waiting for the board to come out and maybe make some kind of announcement. It's just a courtesy to folks to let them know that the board will not be coming back into open session. So no need for you to sit around and wait for an hour, however long, for the board to come out of executive session. Some provisions of the statute require a further declaration that having the meeting in open session will have a detrimental effect on the body's position. So if we are, like I said, gearing up for collective bargaining with the unions, we don't want to have an executive session. We don't want to have an open discussion where we talk about, hey, we are willing to give everybody a 10% raise, but we're going to go and we're going to tell the unions that we've only got enough money for a 2% raise. It's kind of like playing poker and shoving all of your cards. Same thing with like a real estate transaction. We might be willing to pay $1 million for the property, but we don't want to say that publicly for all to hear. We want to have, a strategy. So that would be a purpose where we would say, having that discussion in open session would have a detrimental effect on the board's, negotiating position. And you're required to make that declaration as part of your motion. Go to the next one, Megan. Once you're in executive session, you should only discuss the purpose for which you've actually posted. We've already mentioned that all votes have to be taken by roll call. You still have to prepare minutes of your executive session. I get a lot of questions about when executive session minutes need to be approved and released. All of the minutes that you take for all of your meetings, whether they're open session or executive session, are supposed to be prepared within 3 meetings or 30 days, whichever is longer. Now, if you're if we're talking about open session meetings, the moment those minutes are drafted, they're technically a public record. They may not be approved yet by the board. And you could stamp draft on them, subject to revision by the board. But if somebody wanted to request a copy of those draft minutes, they would be entitled to them. Executive session minutes require further analysis, however. So you might still, as a board, approve executive session minutes in a timely manner. But let's suppose that executive session was about litigation. Well, the litigation is very likely not going to be over by the time your minutes are approved, right? The litigation is gonna go on for a couple of years. So even though the minutes may have been approved by the board, those minutes remain not, they remain secret. They are not available to the public until the purpose for which you've had the executive session is done. So same thing with collective bargaining with the unions. Until you actually have concluded negotiations and you've got a signed contract, however many executive sessions you had, that portion of your minutes remains, can be redacted, or at least it is not a public record until you've actually got a signed contract. The open meeting law also requires that for this reason, there's often a backlog of executive session minutes because we've forgotten that litigation's been going on for 6 years, and I've got 6 years worth of executive session minutes, sitting on a shelf somewhere. The chair is expected to periodically review executive session minutes to see, can any of these actually be made public? And if you get a public records request for executive session minutes, then we've got to look at it sooner rather than later, because you've only got 10 days to respond to that.
So if the litigation is dragging on, it doesn't. If someone requests through public information, it doesn't matter that there's still private negotiations going on.
We would say that the executive session minutes are not a public record because the matter or the purpose of the
Okay.
executive session remains ongoing.
Okay.
Now, what often happens is your executive session was not just for one reason. Your executive session was for about 3 reasons. And one of which might be the litigation that's still ongoing, but maybe the contract negotiations resolved. And so you get that request for those minutes. You can release the portion that's about the contract negotiations. We would have to redact anything about the litigation. In the interest of time, you folks have known, we're getting close to 2 hours, so those are some of the reasons for going into executive session. Purpose 1, to discuss reputation, character, or to discuss charges or complaints against someone. That is a basis for executive session. I do just want to highlight that that is one purpose under the executive session statute that has a further requirement that the individual against whom the charges or complaints or is going to be discussed in executive session is entitled to written notice prior to that executive session. And there's a few other rights that attach to that situation, but I imagine that if you're going into executive session for that purpose, somebody has probably been referred to me to have that conversation so we can walk you through it. We've talked about collective bargaining or strategy sessions for negotiations and purchase of real estate. There are others, but like I said, they aren't as germane to municipalities' regular meetings. Go to the next one. Ellen. Remote or hybrid meetings. So we've talked about technological glitches and all of that. We are still operating under the COVID rules. I know maybe we have kind of lost sight of that. It's been, 4 years, but yes, we're still operating under COVID rules. So the COVID rules will continue to be in place until March. I guess it's the next slide, until like March of 2025 is how long it's in place. And under the COVID rules, boards can meet, thank you. Boards can meet entirely remotely, boards can meet in person and have a hybrid situation where the public or others are remote. This will continue to be the situation until at least March of 2025. There is legislation that was introduced in both the House and the Senate that went to a conference committee that has not been reported out yet. But there is some consideration to take the COVID rules and make them permanent. From my understanding of the hearings at the State House about this, the problem is that there are some communities, primarily in the western part of the state, that don't have reliable internet, so that they prefer in-person meetings. There are others that would prefer remote. And the legislature has not yet worked that all out, but, stay tuned. If there's a further extension, I will certainly let everyone know.
Just one question, is the chair required to be physically present, or could that chair appoint a vice chair or some other surrogate for a particular meeting?
So for the COVID rules, no one has to be physically present. Like, no particular member of the board has to be physically present under the COVID remote meetings. If we were to turn the calendar back 4 years and go back to remote meetings under the open meeting law, which we may see again, but haven't for a while, under those rules, the chair had to be physically present at the meeting location.
The chair could not designate the vice chair?
The chair could designate the vice chair. If the chair, let's suppose the chair was the one that had to be remote, the chair would have to then have the vice chair or somebody else who is physically present act as chair for the purpose of that meeting. Because if we go back to remote meetings under the open meeting law, it just means individual board members could be remote.
Okay, no, we had that situation. Okay,
You still would have to have a quorum of the board physically present, and the public is gonna be physically present. So that's why you need the chair, or whoever's chairing the meeting, to be in the physical room so that they are
it
able.
doesn't have that chair.
It does not, no.
Okay,
But back in those days, you couldn't get a room. Everybody was remote. Right? Everybody was Zoom.
Right, so those are the COVID rules. The
Yeah.
COVID rules is everybody can be remote.
Right, okay.
If the COVID rules go away, and I don't have a crystal ball as to what the legislature will do, but if the COVID rules go away in March of 2025, then all we are left with is what the Attorney General's regulations say about remote meetings, which is that meetings are all in person. Members of the board could participate remotely, not the public, but the board members could participate remotely. But you have to have a quorum of the board physically present. And whoever's serving as chair has to be someone who is physically present in that meeting location.
And, can when you update us in March, like
We
when? if
certainly
we need to
will,
think
or
about
sooner if it
conservation,
should
then We don't
happen.
have to take time going about the weather.
Right.
Wonder ifs.
Right.
At this point,
So
deal with what we have in front of us.
we could skip ahead, let's see. I already covered that, thanks Megan. We've already talked about notice for remote meetings and Zoom bombing. We've talked about access to the meetings.
Announcing the names. Are we also supposed to announce the names of people who are members of the public who just attend in person?
You have to announce the names of the board members.
And then people who are sitting in the audience, we're not,
Nope.
we're not required to
Nope,
identify
now,
themselves.
if somebody actually wants to be recognized and address the board,
To speak.
you typically, right, you would typically say, could you please identify yourself for the record? But you don't have to run through the rows of people and identify everybody as there. The idea being that often when we are in the Zoom environment, people can't necessarily tell who's the board, you know, if we're physically in the room. I would assume that those sitting at the table are the board members because the chairs are for the members of the public in the back. When you're on Zoom, I can't tell a board member from just a reporter from a member of the public, so that's
So
why.
and
you-
that's, I didn't, I missed
Yep,
the word.
nope, that's
That's
okay.
why I'm not a lawyer.
You are also, and if you, remember Megan's announcement at the beginning, you're supposed to announce whether or not the meeting is being recorded. That's just simply out, following the wiretap statute to make sure that, if somebody does not want to be recorded for some reason, well, then they don't want to, they better not come forward and, request to speak. The remote meetings also require that all votes have to be by roll call. Again, I think the idea being members of the public who, let's say you're on a Zoom that has 100 people and you've got, 5 or 6 different computer screens. And I suddenly hear all in favor, aye. I don't know who voted, so we go through a roll call for remotes meetings. We've talked about technical issues. And we've certainly talked about executive session requirements. One other thing that's on this slide is no private chats. This might go without saying, but where all of your business is supposed to be discussed openly and publicly. We should not be, passing proverbial, notes to each other to say, I'm going to make a motion to deny this, just go ahead and make your motion, but don't pass a note to somebody saying that this is what you're going to do. Similarly, I've sometimes seen board members will sit and they'll pull out their phone and they will text somebody. Now, maybe they're just texting their child to make sure they got home safely or they finished their homework. Or maybe they're texting the board member at the other end of the table to say, I'm going to vote against this, how about you? Or I think we should table this. Remember, all of your discussion about the business that's before you is supposed to be transparent to the public. So I've even seen some boards where they will pass a rule governing themselves that they will say no cell phone use during any public meeting. You have to have your cell phone out because you've got a child or a family member that you're concerned about. Well, they can certainly text you and you can get up and excuse yourself, but no cell phone usage during the meeting. We see lots of board members that sit with their laptops. And we assume that they're just scrolling through the meeting materials and saving trees, right? Well, for all we know, they could also be engaging in some sort of back and forth chat about how they're going to vote on something. Everything should be expressed out loud and transparent for the public to see and hear. Covered this. That one. Meeting minutes, do any of you actually prepare meeting minutes or is that, oh, sorry. I didn't know if you had, somebody who was, designated to do the minutes, but, the minutes have to include date, time and place of the meeting. Who was present, who was absent, any votes that were taken, and a summary of the discussion that was had. It does not have to be a verbatim transcript, but it has to be a little bit something more than, discussion of the harbor master's report. We get into a little bit more detail there. There's also a requirement that any documents used at the meeting have to be listed in the minutes. And this is something that when the open meeting law was revised in 2010, this was added.
That totally makes sense.
It does.
Otherwise, you have nothing to go on.
It does, especially that we got this report, that report, what report were they discussing? Was it the initial report, the draft report, the revised report? But the thing to bear in mind is that some people seem to think that you are supposed to keep a copy of that document attached to all of your minutes. You don't have to have the document physically attached to the minutes. You simply have to have a list at the end that says, list of documents used, and it might be application, harbor master report, financial update, whatever, however it was discussed or identified at the meeting. You are required to keep a copy of that document somewhere, however, so that if somebody came in and requested a copy of your minutes of a particular meeting, and then said, well, I'd like a copy of the report that the board was discussing, it should be pretty easily identifiable and available for them.
And by you. do you
By
mean
you,
Me or to
whether-
me, you.
It
George.
tends to depend on, how the request comes in and, whether or not you've got some staff perhaps to
You have a
support you.
clerk?
In my dreams.
All right.
So when we get a request like this, generally it comes in as a public goods of records request. And
Yeah.
so all of those come through Lisa Legg, who's our town clerk. And from there, she kind of distributes them out to the appropriate department. So it'll be a staff member that'll generally get the request and need to fill it.
And find so. I mean, what I usually do in my minutes is I put the link, to a Google Doc link in there so that anybody can access it
How long does the link last though?
in perpetuity until
Okay.
the document is removed by the owner.
Okay, well, it may be though, in that situation where there's doesn't sound like there's a clerk or any staff
Right.
supporting that board. I can't imagine that Lisa,
Oh.
if a request came in, she would have to reach out to the chair of
Board
the
member
board.
or
I
the
would
chair.
think.
Yeah,
To
yeah.
say, someone has requested X, Y, or Z. One thing that does help avoid some of those public records requests and the burden of having to respond to it is just post it on your website. If there's a particular type of report, or lots of boards will have their agendas and minutes, there's a link to those, so you can even go back in time and locate the minutes and any documents that were attached. I know the planning board, and I think the zoning board is doing this now too. On the web page, there is a link that says, active planning board and zoning board applications, so you can click on that and see exactly what's going to be discussed, and there's the whole application laid out for you. That, if we can refer somebody to something on a website, you'll save a lot of time on public records requests. And, think about. The next one is. So you sometimes get some questions too, as to, well, what does it mean, documents used? It means whether the document is physically present, it's verbally identified, or the contents are discussed by members of a board. So if a board member is, waving a document around and somebody said, well, I'd like to see it, do you have copies for the board? Like, no, but this is what, to take my word for it, this is what the document says. Well, you've just made that document a public record because you've identified it and referred to it in a public meeting. So we better get a copy of it so that we have it for the file. I think we've covered that.
The other thing, and maybe you cover this. In the past, I can only speak for the zoning board, but in the past. We had situations where people would submit a document unsigned. Or I got a letter from someone, but they didn't want to be identified. And we said, no, you have to identify the author or of that document, whatever it may be, correct? I mean.
You could do that, or you could also, just. Accept it as,
Okay.
an anonymous note or whatever it may be, and you give it whatever weight you think it should be entitled to. And I,
Not to accept them or tell the people.
you say, well, exactly, it's like, what is the point of submitting something to a board if you're not willing to sort of at least put your name and address to it and identify yourself as an abutter or whatever it happens to be, or what if you don't even live in town, or you don't live in Massachusetts? Don't we give greater weight to say a butter that's gonna be affected by the project as opposed to somebody out of state who is just attending our meeting and submitting comments to us, you know, you could still just accept that anonymous letter or whatever it is, and you could simply just say, I'm going to give it the weight that I think it's entitled to, which is next to no weight to influence my decision, but thank you very much, and there it is. I think we have covered this through most of our discussions. We talked about the 3 meetings of 30 days. Okay, so we can go to the next one. Oh, this is something that applies to all board members, and hopefully this is happening. When you get elected or appointed to a board and you go see the town clerk, probably to be sworn in to take the oath of office, you are supposed to receive a copy of the open meeting law. And you are supposed to certify that you have received it, and the town clerk is supposed to keep a copy of that available. And if you serve on 5 different boards in town, you're gonna get 5 copies of the open meeting law and be requested to sign that form 5 different times. But it sounds like I saw a couple of heads nodding that, yes, that is happening, so I won't spend any more time on that. We can skip that as well. So complaints, as we said at the top of the session, Cohasset, at least in my experience, has not had very many open meeting law complaints filed. If an open meeting law complaint is filed, it's supposed to be filed with the town clerk as well as the board against whom the complaint, pertains. It doesn't go to the select board unless it is a complaint against the select board. Whatever board is the subject of that complaint, you're required to meet and to provide a response to the Attorney General's office within 14 business days. Now, most of the time, what will happen is an open meeting law complaint will come in, it will get forwarded to me. I'll look at it and I'll get in touch with whoever the chair of the board happens to be to make sure that it gets put on an upcoming agenda. And maybe I even get a little bit of information about it ahead of time. You don't need me or town council to help prepare your response to a complaint, but it certainly does help, I think. So you'd have to put the discussion of the open meeting law complaint on your agenda as you would any other item that you were going to discuss. And a copy of the response to the complaint, as I said, goes to the Attorney General. It also goes to the person who has made the complaint. What then happens is the Attorney General will then acknowledge receipt of the board's response. They then wait, I believe it is 30 days. And the Attorney General will then reach out to the complainant and will say, 30 days have now passed since the response to your open meeting law complaint was received. If I hear nothing further from you, we'll consider this matter closed. That's usually the day that most of the complainants will then immediately respond to the Attorney General saying, I am not satisfied with the board's response. I do want this to be further investigated by the Attorney General's office. If that happens, then it gets assigned to somebody at the Attorney General's office who will likely reach out to me if I'm the one who's prepared the response on your behalf. Or if you as a board member submit that response, I would anticipate that the Attorney General is going to reach out to you at some point to ask for some further information, maybe seek to clarify something. And then eventually the Attorney General will issue a written determination as to whether or not she has found there was or was not a violation of the open meeting law. That's what. I mentioned earlier that, one of the reasons to be concerned about this, sometimes I have to always say this. I used to work for a town. I did for 14 years, so I completely understand what it's like to be overworked, understaffed, be expected to be the chief cook and bottle washer of everything. So I recognize that sometimes putting all of these burdens on particularly volunteers, it's a bit onerous. And it seems to be a little bit, picayune, if you will. But the risk of not complying with the open meeting law is that the Attorney General could take some action to, like I said, could nullify your votes that are taken. There was a recent determination involving the town of Nantucket, where they had appointed, I think it was a new planning director. And they didn't follow the open meeting law. They got an open meeting law complaint. The Attorney General said that appointment has been nullified. You've got to do this all over again. The Attorney General can impose fines for intentional violations. And I will say, in my experience, the Attorney General has a very high threshold before finding intentional violations. And usually when the intentional violation is ultimately found, the Attorney General will remind you how many times you have previously been told that this exact behavior is a violation of the open meeting law. And that's typically when a fine is imposed. Otherwise, for the most part, they just want you to comply with the law. So, the first complaint or two that might come in, the Attorney General will simply remind the board that they are required to comply with the open meeting law. They get a few more complaints, they might even compel that there be open meeting law training like this that gets conducted. And the Attorney General wants to see a sign-in sheet that the board members actually attended that training. So it can run the gamut like that. I mean, the Attorney General is not trying to
They gotcha.
play gotcha, I mean, they're not looking to find violations, but they are looking to process the complaints and be responsive on that, so.
Can we go back to
Sure,
where you would come to the board, let's say the 14 days or whatever it is, you would come to the board and help with a response.
yes,
Now, are you representing the board or are you representing the Commonwealth?
I represent the town, never the Commonwealth,
Okay,
so
so you would be advising a response based on what you think the Attorney General would like to see.
if I can,
Yeah.
yes.
Okay.
If you provide me with some facts that help support that, yes, so I might do something like, I usually try to prepare a response in advance to that meeting with the board, based on whatever information I'm able to figure out. So if I can look at the minutes, if there's a video of your meeting, I'll watch your meeting. The Attorney General will watch videos of your meetings too. So I might look at all of that, sort of get more of a sense of what was going on, or what was, was there really a violation or wasn't there? Or it might be, I can't really figure this out based on other materials. I've just got to go and meet with the board and ask some pointed questions to get to the bottom of it. And then that gets incorporated into a response that goes into the AG.
And it's the board that makes the response, not you.
It can be either.
Okay,
I have drafted responses that then the chair might sign. More often than not, I wind up being designated as the person to sign the responses on the board's behalf. But I always make it clear when I send the response in that we represent the Cohasset whatever board, and this response is being submitted on their behalf.
Can I ask one more question?
Yes,
I mean,
absolutely.
You guys don't all have to wait for my one question, but I feel like I now understand things that we can't do. I'm still not sure how to get anything done. So, and one of the specific questions I have is the difference between opinion and advocacy versus clarifying facts. Because you can't make a decision, you can't have an opinion if you don't know the facts, and I feel like the sharing of facts is facts, not an opinion. So where's the line on that? Like, how do you know?
Well, regardless of whether you're sharing facts or you're sharing opinion, it should be done
Public.
at a public meeting.
Okay, so then, all right, so we're safe if we're staying within the map.
Yes,
Okay, so then. And then if you're trying to get clarification from somebody, you need to do it one-on-one, not with like two of your buddies who happen to be on the board with you.
well, unless you're also able to do it in the context of
The
the
meeting.
board meeting, yeah, exactly. You know, like, for example, if you needed clarification from the harbor master and the harbor master is there. You should be allowed to ask questions of the harbor master,
You mean during the meeting?
yes.
Yeah, I mean, if you're trying to get your head around an upcoming topic
Mhm.
and you're trying to figure out, you know, what the deal is, what is it all about?
What do I need to know? I wanna get up to
So,
speed.
yeah, I wanna get up to, exactly, I wanna
Yep.
get up to speed, I
Yep.
don't wanna go into this meeting and just go, cause lots of people, I'm a teacher, so I see that, you know, like the, yeah, you're not reading that. So I do like to know what is going on, so I can do that as an independent person, I can go hunt down information from anybody I want, as long as I do it privately. One-on-one, not as a, what's that word, begins with an S, a
As
series.
long as it's not like a serial conversation.
Serial conversation,
between-
yeah.
So if you,
So it's just me and I'm going to you and I'm asking you about this and I'm asking you about that and then I'm asking somebody else about some,
I would
because
say,
I wanna figure out what, like if
yeah.
I were to go try to assess the needs of people and the wishes of people. I can go out and ask people,
Well, let's be careful on who the people are. Yes, you can go out and ask people. But I would not go out and ask your fellow board members. Or a quorum
Yeah.
of your fellow board members, except when you're actually at the meeting to
okay,
discuss that. You know, so if you want to go meet with the harbor master so that you can. Get up to speed on something or wrap your brain around something that maybe, maybe you just got appointed to the board last week. And everybody else has been on the board for years and you feel like I'm kind of a little bit at a disadvantage here. You can absolutely go meet with the harbor master as many times as you want to get whatever that background information is that helps you. You can talk to members of the public
and I can talk to members of the board as long as it's not more than one of them. At a time.
and
or
I'm
whatever,
assuming.
less than that.
And I'm also assuming it's not a 3-member board in that scenario.
No, it's not, but then we have. Okay, that brings me up my next question, subcommittees, so we thought we were gonna set up subcommittees to make it easier to get things done, so we would be less. Lengthy in our board meetings, but then it turns out that the subcommittees have so few members on them that you have all these quorum issues. So if we have a 3-person subcommittee, then if 2 of us have a conversation, we're in the majority. So then that needs to be
Whoa, I didn't pick that up.
minutes and
No,
an
we
open
did-
meeting.
Wait a minute,
We do
isn't there a
subcommittees all the
distinction
time.
between if that subcommittee is empowered to make decisions?
Yeah, or
opposed to
vote,
gather
yeah, no
facts?
voting, if it's just research.
It doesn't necessarily has to do with the voting. It has to, what is the nature of the business of that subcommittee? Why has that subcommittee been formed? What are they being asked to do? And again, if your subcommittee winds up being a quorum of the parent body, it's absolutely an open meeting law, a public meeting discussion.
That kind
Yeah,
of.
I don't think that's what she was driving.
Right, I think
But-
we intentionally maybe even made our subcommittees small, so we
Yeah.
wouldn't get into
Mhm.
that, so that we were hoping to just like.
Yeah.
Have more casual conversations, get
Mhm.
things done, and then present them to the larger
Hmm. Yeah,
board.
that's the way we use it.
Don't arrest me now.
Yes,
She'll
no,
defend
no.
I'm trying my best, people.
She'll
You're-
defend
I
you.
believe in
No
democracy.
one's going to get arrested, no. Even though that may be less than a quorum of the public body. So you've got a subcommittee that is not a quorum of the parent body.
Yeah.
You'd really have to look at what is that board? I mean, it's clearly a board that exists within government.
Yeah.
It's expected to deliberate some business of the parent body.
subcommittee.
Yeah.
Right, it's like
Um,
the purpose of them, we thought was to deliberate.
Mhm. You're going to deliberate, I mean, you have to deliberate, because how else, how else you move something forward, right?
Exactly, that's where I'm lost.
I think the Attorney General would likely say your subcommittee, because the parent body is subject to the open meeting law. The subcommittee is also subject to the open meeting law. Doesn't mean you can't have a subcommittee, doesn't mean
We
you still
just need
can't.
to, but we need to
move
post
things
it
forward.
48 hours in advance, and we need to
Right.
have minutes, and we
Right.
need to make it open to the public.
Right,
We don't do anything like that. Maybe that's a problem. I mean, we have a elder affairs. We have a subcommittee to go out and on transportation, because we're always buying new vehicles and whatever. We assigned 2 people to go off and get some specs on types of vehicles that we wanted. They came back and it was clear what they picked, what to the advantage of what we wanted. But they came back with all the facts and diagrams and prices and what have you. And then the board pretty much decided, but there was certainly a bias from these people that went out and visited different places, what they would want us to select, and that's what we did select. But again, it was 2 people on a 9-person board, so I don't know.
That's what you asked them to do.
yeah, I was gonna say, they're not making a recommendation
Well, they
to
are.
you.
They did recommend to us. They said, after everything that we've seen and the prices, what have you, this is what I think we should go for. And they explained everything to us and we agreed with them.
So that seems like a good way to get things done.
Yeah.
So what is the proper
But
way?
it's two
but what's-
members of a 7-member board, is that
2
what it
members
is?
of a 9-member board.
This is not a quorum.
So you're safe as long as you don't call it a subcommittee.
Doesn't matter what you call it, because believe me, there's determinations on that, you could call it
That seems like
subcommittee, you
such
can
an
call it
effective
working
way to
group.
get things done, like.
I
Two
wouldn't,
people with a.
respectfully, I wouldn't consider that scenario to be a subcommittee. That's more like 2 people being sent out, I like Woody's, you've been sent out like on a fact-finding
Yeah.
mission. Come back and provide more information to the rest of the board so that we can sift through this, so that the 9 of us don't have to do this all individually.
Why wouldn't you call it a subcommittee?
Are they meeting together? Are
They're going
they?
together, they're traveling together.
Well,
I mean, it seems so much easier to just call it, because then I can say that I need my subcommittee reports during a
But if
meeting.
you're then calling it a subcommittee, they should be posting their meetings.
I need
But
my
you know,
friends to report
you know,
to me.
well, I know.
I don't want my friends, they're my.
It is.
I would think, I
That's
would
what you heard from Harvard
question. I would think, making a fact finding and making a recommendation, even if it's obvious or not, is different than making a decision. The board could clearly overrule
Yeah,
Right,
this 2-person group because, either there's, I don't know, who cares what the.
that makes logical
But
sense.
it's-
But that's usually the case with every subcommittee, right? Every subcommittee is basically
Almost by
just,
definition, you mean?
almost by definition, they don't have any independent power.
right.
They just
Recommend.
present a recommendation or narrow the choices down and then present it to the parent body. So I don't know that that's going to necessarily make a distinction for you between a subcommittee and some loosely held committee.
Could I
of
just
people.
quickly throw my thing in
Well,
and then
just
you
to
guys?
finish on that,
All right.
does that mean that if I view it as a subcommittee and I call it a subcommittee, we should be posting the subcommittee's trip to a particular vendor?
If it's technically a subcommittee of your board, yes.
Okay, I'm gonna change some names.
Yeah, that's right, there's gotta be a.
Yeah,
Come up with a
You
creative
know,
workaround here.
changing the name may not necessarily get around it.
We're gonna use gang
Um,
signs instead.
But again, if there is like, the board's designee is going to go to this particular vendor to see whether or not that van might be better, or we want to switch to an electric fleet or whatever it is. It's not really a subcommittee. They're not sitting around and debating. They're just kind of going on a field trip.
Collecting information
Yeah.
and making a recommendation.
Mhm.
Then that strikes me as being very thoughtful and deliberative, because you're acquiring
Which is
information
one
and
of the
you're
reasons
weighing it
why
and being
the
a
Attorney
human.
General would say, so post the subcommittee's meeting, because they are deliberating, aren't they? So. We
Like, I like that
we
idea,
kind of
though,
get
yeah.
stuck in this circular argument, but.
Sure.
You know, it's one thing, you know, somebody could just as easily perhaps do some of that same research online. They don't really have to go someplace to
What
find
difference
out.
would that make?
Hmm?
What difference would that make? Again, two people do it online.
Because it isn't members of your board then meeting and deliberating together. It's, you know, like a member said, well, let's see what van has better capacity or.
Yeah.
But they would be deliberating by email.
If they're discussing amongst themselves, yes, but I'm saying like, you know, in your situation, like, you know, have them go out and check out transportation or what might be better or worse for
Yeah.
somebody. If it's an individual who's doing that, whether it's a field trip to a particular vendor or doing online research to compare gas mileage or whatever, that's not a meeting. That's just one person doing some research. I mean, the bottom line is always going to be when in doubt, treat that subcommittee as a board that is subject to the open meeting law. When you had one more question.
Yeah, I mean, this comes up at zoning a fair amount. And that is, there's no application before the board. But somebody has heard that so-and-so is planning a development down the road or doing this. What do you know about that? Is this going to be similar to something else? But we have no application or paperwork in front of us. Does that constitute a violation of the open meeting law if we're just simply saying, what do you know about this? Is this a subdivision or is it not, or don't they?
Right, so the first question to be asked would obviously be, was this a topic that the chair reasonably anticipated would be raised?
Just done
Probably,
casually.
probably, you know, probably not in the scenario, and I think I've actually been at some of your meetings where at the end, it's like, so what's going on with such and such a project, or while we have the building commissioner here, let's ask for an update. It is not necessarily a per se violation to not have it on your agenda, number one. Number two, it really comes down to, well, how far does that discussion go? You know, if the discussion is, hey, you know, on my way to vote on Tuesday, I drove by and I noticed that they appear to have started work on this site. Do we know that a building permit is issued? That's fine. That's fine. If.
You can create a subcommittee.
And you're the first person I'm gonna put on it.
I can tell, I'm gonna be persona non grata around there.
But a lot of it happens, or something's before the planning board. Is it likely to come to the zoning board? We don't know, but
Mhm.
do you think this is going to be something we're gonna have to get involved with or not, or is it? I don't know. I mean, sometimes those conversations are casual, just as kind of a heads up.
Yep,
And a curiosity and a time saving and everything. It's.
yeah, I mean, I think there's gotta be, you know, we don't throw common sense out entirely, so, you know, if there's just a. You know, a passing comment, like you said, does anybody know what's going on with this, or, oh, by the way, I understand that this application has been filed, so. You know, I would expect that they'll be coming before our board or something like that. You know, that sort of just, you know, you're not deliberating, you're not expressing an opinion. You're not getting into the weeds of an application or anything like that. That limited conversation is perfectly fine. If it starts to go further than that, you know, like, for example, if a board member said, gee, I just noticed that they've started some work at such and such a location, and I thought that they weren't supposed to start work because they haven't satisfied this condition yet.
Or that building looks pretty tall.
Or that building looks taller than my 35 feet or whatever it
Yeah.
happens to be. What I would suggest the board do at that point is put it on your next meeting agenda for actual discussion. And perhaps there's also some outreach to the building commissioner or
Absolutely.
staff
Don't know.
to get more information, and then it's on the agenda for the board to formally discuss. And if the property owner or developer wants to show up at your meeting and answer questions, they know it's on the agenda. They might even be invited to come in. and meet with the board.
And then, as long as it's one person who goes to hunt down the information and not the quorum,
Right,
or something that could be
Right.
considered a subcommittee.
right. Yes, and at this point, I think we're all kind of like punch time.
Well, this was quite an hour meeting.
This was quite an hour meeting, yes,
Because
indeed.
at the end of every single meeting, meetings adjourned, and boy, now everybody talks. Because when the meeting is so formal.
Get rid of that slide, no more quick.
Yeah.
Yeah.
Yes,
But
Okay,
that's
everybody's
not today,
leaving.
right?
Are there any watchouts for one board member to talk to the member of another board about a situation? Either, you know, does your board have jurisdiction here, or what are you finding out? Are we like, is that okay or not?
that's okay,
Okay,
that's okay.
sometimes I get asked about.
Yeah, no, because I think I remember one of my first meetings was you and the chair of the planning board and some other folks and, oh, look who's here?